Right out of the gate, we're not just talking about an assault, we're diving into something far darker. The courtroom atmosphere is tense, and you can feel the moral gravity here. Torture, betrayal, and a shocking lack of humanity. This isn't your average case.
This was just not an assault. It was just not a kidnapping. This was a torture of another human being.
She's the one who should have called the police. She didn't. She saw what was going on.
These guys all knew him. They were doing this to get his disability checked. They beat him so bad that he has lost sight in his left eye. He does not have sight in his eye anymore.
Later, they took him into a shower, kept him tied up.
He remembers her specifically, the look in her eyes. Said she had a look in her eyes as if she was enjoying it while she was kicking him.
Why would you do such a thing? I mean, there were 4 of you. Was that enough? What case is to be dismissed? Is that right or not?
Yes, sir.
Aggravated robbery, aggravated kidnapping.
Come forward, please. You were Queta Wetherall.
When the judge mentions the case to be dismissed, don't get confused, this isn't about letting anyone walk free. It's a procedural step, often tied to plea agreements. The key here is what's left standing: aggravated kidnapping, a first-degree felony that carries the potential for life in prison.
Mr. Grove, your attorney and the state's attorney, earlier you pleaded guilty in 23 CR 24, the first-degree felony of aggravated kidnapping. A pre-sentence report has been prepared. The parties had an opportunity to review it. And are there any corrections or changes to it? First of all, from the state?
No, Your Honor.
And defense?
Yes, Your Honor. There are several changes that we would like to make to the report.
Okay.
And I'll address these kind of in one large things, although there are spread throughout this. Under the defendant's version on page 1, the probation officer basically says that Miss Wetherall did not accept responsibility, did not say she did anything, and therefore was not being truthful. After going over this with Miss Wetherall, and I was not present during the interview with the probation officer, I believe that Miss Wetherall did not understand much of what the questioning was, and there were a number of things that she would indicate that she would, or could be indicative that she was not involved in this. She was involved. She accepts responsibility, Judge. This occurred in her. I'm sorry.
Look at it on page 4, David. It says, yeah, that's the key thing that bothers me here that we need to talk about. It says, despite pleading guilty, the defendant never accepts responsibility. She did not know what was happening to the victim. She went to the bedroom, go to sleep, didn't find out until waking up, was blaming alcohol use as the reason she passed out and does not remember anything. Okay, so that was the summary of the recommendations by the report that are disturbing.
Miss Wetherall was the person who was the leasing at this apartment. This was on Super Bowl Sunday. Miss Wetherall and 3 other people went to a Super Bowl party at another location. It was over sometime after midnight. They came back to Miss Wetherall's apartment. She was the only tenant there, the only one on the lease, the only one that had responsibility for the apartment. Basically, sometime after 2 o'clock, they came back. Mr. White, the victim in this case, was not present. Someone brought him, an Uber driver brought him over to the apartment. The 2 men that were involved in this and Mr. White were in the apartment next door, apartment 249, not Miss Wetherall's apartment. But Miss Wetherall could hear what was going on through the walls and could tell that somebody was being beaten or arguing this type of thing. She did not do anything about that. Later, they brought him, the two men brought Mr. I'm just having a real hard.
And here's the chilling part: imagine hearing the screams through your apartment wall and doing nothing. That's silence? In the eyes of the law, it speaks volumes. Failure to act when you have a legal duty can be just as damning as taking part directly. This is where morality and criminal liability start to blur.
Name Mr. White's name, brought Mr. White over to her apartment, and then the beating sort of continued. I think if you read the police reports, and I think the probation department representative will agree that the two men were the ones that were mainly involved as the main participants in this. But it was Miss Wetherall's apartment. She's the one who should have called the police. She didn't. She saw what was going on. Later, they took him into Mr. White into a shower, kept him there, kept him tied up apparently until later that day, when sometime around 2:30 in the afternoon, more than 12 hours after they had returned from the football game, the police arrived, and they were called about that. And Miss Wetherall knew what was going on. She'd been drinking. She was not in the type situation that she should have done more, but she did not. And that's the way that it is. Now, as far as striking Mr. White, she doesn't remember, striking him, although he told both of the police, or several of the police officers, that all four of the people did kick him when he was laying in the floor. Miss Wetherall is 36 years old. If you look at her criminal responsibility is one hot check and one traffic ticket. This is an aberration. This is not what she has done. In fact, in January of this year, and this occurred in February, she received her TWIC card and had a job that she was to start for the B&S Railroad as a switching person. She had not started this job yet, but she was supposed to start this job. She got involved in some people that she should not have been involved in, obviously, did not do a very good choice of who she was associated with on this occasion. But again, that's not indicative of what's been shown in her record. She also, when the police were called, the other three were all arrested on outstanding warrants for other occasions. Miss Wetherall had no outstanding warrants because she had never been charged with anything. In addition, on page 2 at the top, it says that Mr. White is concerned about having to go back to the same apartment complex because he's afraid that people will beat him again, things of that nature. Miss Wetherall has moved out of the apartment. She's moved back home with her parents, Reverend Raymond and Geraldine Warner. She will be living there with them if she is put on probation and is going to get away from this lifestyle that she was apparently attempting to adopt. She also has graduated from Westbrook High School. She attended and graduated from Vista College and received a degree from them. She's attended Lamar Port Arthur and has like one class left to get that. She had a wonderful opportunity to make something of her life, and things were going real well until this incident here. And this incident is just it's terrible. There's no two ways about it. But I think it is an aberration, and it's something that she will not do. When this occurred, the other three were taken to jail. She went down and talked to the police.
Pause for a second. Do you believe this was a one-time mistake or a reflection of character? Defense attorneys often lean on the aberration argument, meaning the crime was completely out of character. But can a single act of cruelty this severe ever be dismissed as a momentary lapse?
But she was not arrested until a week later or something like that. But she's also been in custody more than 6 months for this offense. And basically, there's no excuse for her doing what she did by not calling EMS or calling 911 or calling the police. But she realizes that she had a moral and a legal responsibility to do that and just didn't do it. And I think that she will tell the court that she accepts responsibility and would ask the court again to give her probation. She's not like many of the people I represent who had other troubles before. This is her first criminal arrest, and all that is reinforced by the probation report. So I'd ask the court to grant her either deferred adjudication, considering this is a first-degree felony, or at least grant her regular probation on this matter.
All right, Stan.
Judge, if you remember correctly, the co-defendant, Miss Rebecca Foyle, tried the same defense by saying she did nothing. She was in the other room, and then finally admitted that she was out kicking this gentleman. They were doing this to get his disability checked. They beat him so bad that he has lost sight in his left eye. He does not have sight in his eye anymore. He was hospitalized and was badly injured. And Judge, the funny thing is these guys all knew him. They all knew, every one of them knew him. I know that the men were more culpable as they did most of the beating, but these women were while he was on the ground and helpless. This complainant, Mr. White, said he still remembers everything that occurred that day when he passes by. And he said that he remembers her specifically, the look in her eyes. Said she had a look in her eyes as if she was enjoying it while she was kicking him. I took it into account, her lack of criminal history. I took into account the fact that she was not as culpable as the two men, even though they were kicking this man while he was on the ground. He was taken to the bathtub to be basically, as the court explained last time, almost waterboarded. He was boarded. He was tortured, basically, trying to get him to tell where his disability check was. I limited her exposure to 10 years, just like I did Miss Foyle, because of her limited history. And I think that the 10 years in prison is a fair sentence. I think it's more than fair under the circumstances for what they did to this man, who was a former friend. He was a roommate of Miss Foyle, and I believe a roommate of some of these others that were involved in this. And so I think we should send a message to her and to these people that were involved that this violent behavior to rob someone who wasn't doing anything but just coming over to the apartment, it should be sent to them that this will not be tolerated in this county. So we're asking for the 10 years in prison.
Anything you want to say? Go ahead.
I just want to say that I'm sorry. And so you mentioned that Mr. White, I'm very ashamed that would happen. You honestly wouldn't know me, and that I'm in church and I'm a pastor's daughter. Sorry.
Oh yeah.
That I'm sorry, and I'm very ashamed.
The report here states that was prepared by the probation office, which is very in-depth.
The victim's statement hits like a punch to the gut. A fractured neck, a damaged spine, permanent blindness, and yet, what stands out most is his confusion. He still doesn't understand why. That confusion, that sense of betrayal, often lingers longer than the physical pain.
That the complainant, the victim here, still remembers everything that occurred. Every time he passes by the location, he says, where this occurred, he's reminded of the severe beating he had to take. And he doesn't know why or nor understand how the defendants would attack him. because he would have helped them if they needed anything. The defendants took turns beating him with their hands and objects while his hands were tied behind his back. He says, while you were assaulting him, you had a look in your eyes as if though you were enjoying it. That you were kicking him in the head while he was on the ground. He suffered a fractured neck, a fractured back. His teeth were all loose, and he now needs surgery on his left eye. That's serious. I mean, that's just cold-blooded. Let me ask you, I mean, why, have you ever been involved in kind of risky behavior before? At all? Never?
Yeah, like I said, I'm a church girl and bad situation.
Okay.
You moved back in with your parents, and you're gonna stay with your parents, aren't you?
Yes.
Because I'm not sure if that probably had something to do with the location where this occurred, those apartments. But that's speculation on my part.
Were y'all using drugs that night? Illegal drugs at all?
No,
Ma'am?
no, just beers. Those that's it.
Sure. You pleaded guilty to this first-degree felony of aggravated robbery, being a party to this. What did you do? What did you do wrong?
Judge, just for the record, she pled guilty to aggravated kidnapping.
I'm sorry.
Not
I'm looking at
aggravated
this.
robbery.
Aggravated
And
kidnapping.
I don't know that that makes any difference. But
Well,
I just
it's-
want the record to be clear.
They're both bad.
Yeah, well, yes, sir. I'm not trying to say that. I just wanted to keep
You're
that
right.
clear.
I'm gonna put that aside. So on this aggravated kidnapping, first-degree felony, what did you do wrong?
I realized that I should call them.
Ma'am?
I should call for help. Give them some help. To call the
No,
ambulance.
what did you do wrong?
I didn't stop it. I didn't stop it. I didn't
You didn't affirmatively do something?
Yes.
You didn't kick him like he said you did?
Yes.
Okay. While he was incapacitated, you were kicking him. Is that right or wrong?
Yes,
Why would you do such a thing? I mean, there were 4 of you. Was that enough people to hurt him? What do you think kicking the man in the head is going to do? You don't think that's going to severely hurt somebody?
Yes,
But y'all weren't using drugs or anything that night?
not on my part. I'm not sure what they were on.
Have you ever had a problem with drugs at all? I'm just curious. Okay.
Although, Judge, there is a report, the probation officer asked her about drugs, and she did admit she has used drugs.
What?
In the past, and
What drugs? What drugs? What drugs?
It was a long time ago.
Marijuana and alcohol were the 2 that were mentioned, Judge, in the pre-sentence report. Yeah, but she did acknowledge that she did use drugs already.
Well, in the report, it says methamphetamine,
Yes, sir.
encyclidine, PCP. What's used to embalm animals. LSD, synthetic marijuana, all of those are hallucinogenics. They're terrible. But correct me if I'm wrong, but you have been hospitalized 20 times for this.
You know, it is on.
This says you have a history of 20 hospitalizations, right?
It's not just for that one thing. I got in car accident when it was.
For different things, but they include drug abuse.
No, sir.
All of those are crime, methamphetamine, PCP, LSD. Those are serious felonies.
That was that one time I was.
One time,
That was all on my system. That one time I went to Bental, I got in a car accident. And I was there for a while. There was a nurse.
no, wait. At one time, you had meth, PCP, LSD, synthetic marijuana, all in your system at the same time? I don't think so. That you would have never survived that.
My parents are in the audience. They can let you know.
They don't know. They weren't there with you. Were they? Did they see you ingest those drugs? Did they see you ingest those drugs?
Yes.
Well, then they wouldn't know the real truth, would they?
They were there when the doctor told me that it was in my system.
I just,
Changed,
ma'am.
I've changed. I'm not that person.
Well, no. You committed this offense this February. God bless. What do you mean you changed? Are you changing for the better or worse?
For the better.
Well, this was terrible. You almost part of almost killing a man. This is just very cold hearted. What's state asking for?
10 years, same as Miss Full got.
Yeah.
Probation department says she set for trial in September. I'm sorry.
No, we just sentenced her.
Uh,
Anything else? If nothing else, I'm going to find in this case you have pleaded guilty to this serious first-degree felony of aggravated kidnapping voluntarily, knowingly, intelligently. See, what you pleaded guilty to is intentionally and knowingly being a party to abducting the victim. And you committed that with the intent to facilitate the commission of robbery or to facilitate the flight after the attempt or commission of robbery by inflicting bodily injury on the victim. And it's just not bodily injury. This has to be all deemed as serious bodily injury, which is threat to his life. Well, your plea was entered voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement that, by the way, was fashioned to a maximum of 10 years in prison. But as you know, you are exposed to life imprisonment for this offense. Do you understand it? I now find you guilty beyond a reasonable doubt of this serious first-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department.
10 years behind bars, that's the final call. But listen to the judge's words. This wasn't just a kidnapping or a robbery. This was torture. In a courtroom full of procedures, paperwork, and legal jargon, this statement pierces through the noise, a reminder that justice isn't just about the law. It's about humanity.
Criminal justice to serve a term of 10 years. You will be given credit for all time you have served toward this offense. This was just not an assault. It was just not a kidnapping. This was a torture of another human being. That's inhumane. that, I can't imagine treating another human being like that. One of God's creatures. And there, you did a terrible deed. The aggravated robbery will be dismissed
Yes, sir.
as part of this agreement.
Sir.
Yes, ma'am.
You did an affirmative finding on Rebecca Fuller.
Well, she's can stand by. What are you asking for on the affirmative finding?
It was not a weapon used.
Feet, hands and feet. No, actually feet, they kicked. You may not want to, I don't know, it's up to you.
It says inflicting bodily injury. It doesn't say inflicting serious bodily injury.
Yes, sir.
So an affirmative finding is not made that a deadly weapon was used for her. Ma'am, that makes a difference in parole.
And how much good time?
Plus, that you're parolable in 1/4 rather than 1/2. That you would have been had I assigned an affirmative finding. So I'm not. You will be released earlier. Anything else? That is all.